Distinguished Visiting Professor of Law at the West Bengal National University of Juridical Sciences. Additionally, he holds the position of Honorary Professor of Law at the Maharashtra National Law University, Aurangabad, and is an Honorary Visiting Professor of Law at the Damodara Sanjeeva National Law University, Visakhapatnam. He has authored and edited 11 books, along with contributing to 16 anthologies. Moreover, his 119 articles in reputed law journals worldwide are a testament to his dedication to advancing legal knowledge. His latest publications include the 14th edition of P.S.A. Pillai's Criminal Law and Halsbury's Laws of India, volumes on criminal law and criminal procedure, among others. Many of his books are recognized as essential textbooks in both Indian and foreign universities. Sir is a dedicated life member of various prestigious organizations, including the Indian Law Institute, Indian Society of International Law, Environmental Scientists Association of India, International Jurists Organization, South Asian Society of Criminology and Victimology, and the IUCN Academy of Environmental Law, Ottawa, Canada. His engagements on the editorial and advisory boards of several distinguished universities and journals exemplify his role as a thought leader in the field of law. Sir, it is indeed an honor to have you here. Stage yours.
Good afternoon. Good afternoon.
Good afternoon, sir.
Before I start, let me just take a moment to express my deep gratitude to CMR University in general and Dr. Shriya Subramanian at University, the director, the Honorable Vice Chancellor, for extending this invitation to this person to interact on very important topic, the use of forensic science in necessity. Equally, I am grateful to Dr. Vibhute for inviting us in the inaugural session. We learned a lot about insight which we can have in criminal law reforms. Dr. Gaurav Jadhav, who has come from the National Forensic Science University, of course, he is going to give me a lot of input. Now, I want to extend my apologies for two reasons. I have not prepared my PPTs, is one, and I am having sore throat, so probably I may be coughing in between. Please excuse me for that. My topic is use of forensic science in the administration of criminal justice in India. Some reflections on the existing and emerging investigative paradigms. So what I'm going to do is that to look at the legislative frameworks which are emerging and which are in place, which deal with forensic use of forensic science in administration of criminal justice as such. Now, in the morning in our session, Dr. Shashikala Gurpur has already spoke about criminal justice scheme and the forensic science. I want to take a step ahead. Now, if you want to see the use of forensic science in seizures and criminal justice scheme, one has to understand three major concepts, which is a must for a student of criminal law. One is CS, other one is CJS, and third one is CJDS. Now, CS stands for the criminal science, where we need to have a fit into four disciplines or four subjects. That is the criminal law, criminology, which is a science of crimes, penology is a science of punishments, victimology, which talks about victims of crime. Then CJS, the criminal justice scheme, which is composed of four subjects or four so-called major subjects. Indian Penal Code of 1860, which is likely to be revised very soon, all the three. IPC, CRPC of 1973. Originally it was 1898. Probably you know that. The Indian Unionist Act of 1872, the Constitution. These four do compose criminal justice scheme as such. And then we need to have back of our mind about CJDS, as criminal justice scheme, where we do have four players: investigator, adjudicator, investigator, prosecutor, adjudicator, and custodial managers. Now, all these four have to be connected with use of forensic science. My understanding of forensic science is very rudimentary. I say forensic science is that one where science can be used for crime detection and identify a person. Now, if you look at this CJS, now CJS gives us a kind of framework about use of forensic science in criminal administration. Now, if you start with constitutional law, which came after independence, but it has got certain basic elements of having connection with use of forensic science. I will come to this constitution on it later, but let me take you very briefly about these three legislations which do have some bearing on forensic science and its use. Basically, CRPC. Now, CRPC allows the criminal agencies to look into forensic science. For example, Section 45 is fingerprinting. Section 45 of the Evidence Act. Section 40, let me check that one. Yeah. Now, CRPC, Section 40 of the Indian Evidence Act allows opening of an expert in the matters of science. And science plays a significant role in identifying handwriting, fingerprint, signatures. So therefore, Indian Evidence Act has some kind of connection with the use of forensic science in identification of persons in criminal administration. Now, in addition to this one, please do remember that Section 45, also expert opinion, but it has got only probative value. It cannot be the evidence on which conviction can take place. You should remember this one. Now, when it comes to CRPC, there you find certain provisions which do talk about or have relevance on or reflection on use of forensic science. For example, Section 53A, which was inserted in the code in 2005, mandates a medical practitioner to have medical examination of a suspect who are accused of committing sexual assault. And this includes biological sample. Biological sample is 53A, we filed in 2005, inserted in CRPC. Then 54 CRPC provides for medical examination of arrestee. And therefore, you find this what you have a kind of framework which does deal with use of forensic science, Evidence Act and CRPC. But if you look at the constitutional law, all these three provisions, basic provisions which allow use of forensic science, have to be seen in the context of constitutional law. Now, constitutional law today morning, Madam referred Article 21, which talks about personal liberty, life. And here is a dignity. The dignity. Now, therefore, the use of forensic science cannot be at the cost of infringing dignity of an individual, that is suspect. Then we need to refer to under provision Article 20, Clause 3, which gives a right to remain silent, right against self-incrimination. No person can be compelled to be witness against himself. And therefore, this Article 20, Clause 3 can be seen as a kind of inalienable right given to a suspect, deny the kind of forensic samples to be used against himself. But even if you look at this one, that you find that there is no unanimity among the judges. Some judges do say that taking sample for forensic examination does not violate Article 20, Clause 3, but some judges do take opinion that yes, it violates Article 20, Clause 3. Therefore, there is no unanimity among these Supreme judges if you look at India's case or Selby's case. Now, therefore, we do have a kind of rudimentary system of use of forensic science. But when these laws were enacted, original system, 1872 Indian Evidence Act, original CRPC 1998, IPC 1860. Now, therefore, at that point of time, this forensic science was sort of rudimentary stage. But subsequently, we do have a kind of advanced technology in the form of DNA technology, which is much more advanced, which helps us identify an individual by examining small quantity of evidence. Maybe hair, maybe saliva, or maybe any other. Now, therefore, we do have this one, but DNA has been used in almost 60 nations as a tool to identify, suspect, and thereby detect commission of crime, and thereby convict. Because morning, both the inaugural address and we are talking about conviction. But I do have my own reservations. Conviction cannot be the criteria for judging failure success of a system. Conviction, if suppose it is a wrong conviction, now it goes against the constitutional spirit. Wrong convictions. Now therefore, what is the kind of parameter of justice? Justice is an elusive term. And therefore, when you talk about justice, you need to talk about three players in the justice system. Who are they? If you look at the criminal law system as such, they talk about three things. I, that is individual. T, that is they, that is community. And it, that is state. It is a kind of interplay between two or three parties, individual, community, and the state. Now, justice to whom? Now, basically, justice has to be fair. Dignity of an individual who involved in criminal agencies should be treated with human dignity and respect. So, therefore, justice cannot be a kind of overriding effect at the cost of violating rights of individuals. Therefore, we need to look into use of forensic science in the context of CJS, CJDS. Now, therefore, we do have a kind of rudimentary system or scheme where you allowing forensic science as evidence, because evidence plays a significant role in conviction acquittal. And please don't forget that we Indian legal system has adopted adverse event system where everyone of us are supposed to be innocent and the contrary is proved. And we do have a right to remain silent. Now, therefore, evidence plays a significant role in seeing conviction or acquitting a suspect. And therefore, we need to talk about this. Now, in order to have this kind of use of DNA technology in criminal law system, Government of India has brought in the DNA technology with a regulation bill in 2019. As Madam said, government will do it on 24 July 2023. It will do now. But notice when I want to have a reflection on this, because it's a kind of emerging kind of system which is coming up. Therefore, it is always better for a student of criminal law like you and me to peep into that system, what is lurking in the mind of the policymakers when it comes to DNA technology. Now, therefore, I will be reflecting upon this one, and the existing one is there already, which allows DNA technology to some extent. So, therefore, I will be having my reflections on these two legislations. One is in place, and one was in place but withdrawn by the government. Now, DNA technology bill 2019 had a long history. Initially, the bill was prepared in 2007 by the Department of Biotechnology. Now, till 2016, it kept dormant. 7 it was prepared. Till 2016, it was kept in dormant. And in 2016, it was listed for placing it before the Parliament. And in 2017, the bill was referred to Law Commission of India for examination. That means the government was suspicious that something is wrong with this bill, and therefore government wanted to seek an opinion of Law Commission of India about the bill of 2016, which wanted to place before the Parliament for for discussion. And Law Commission gave its report in 2007 itself, but with a caution. Caution was that this bill is need of the hour, but at the same time we should take note of the human dignity, the human rights. Article 20 clause 3. Article 20 clause 3. And therefore the Law Commission flagged that the privacy concerns should be taken care of when we want to enact this bill. Now the government placed this bill in 2019, in January 19, before the Parliament. It was passed by Lok Sabha, but it could not sail through Rajya Sabha for the obvious reasons. It could not sail because BJP doesn't have majority in Rajya Sabha. Therefore, the bill was turned down in Rajya Sabha on a number of grounds. Major concerns was that this bill doesn't respect the right to privacy. Right to privacy, Article 21. And again, this bill was submitted in July 19, and it lapsed in the first one. Again, was submitted, it was put on the floor of the House in July 2009. July 19 was placed again. But it was referred to the Joint Select Committee in February 2021. And again, the Joint Committee cautioned the government that this bill needs to be revised in the context of right to privacy and some ethical rights and human rights. But the government played it safe. On July 24, 23, it will do it. Now, why did the government withdraw it? That's a question I will answer it later because my topic is reflections. Now, let us know what was there in the bill of 2019. What is that? Why there was opposition to this bill when DNA technology has to be used in criminal justice system to ensure more conviction or maybe something else. Now, if you look at this bill, its silent feature is that it provided a kind of broad structure for DNA technology. It created a data bank, DNA data bank, where the 5 types of indexes will be kept in store. That is crime scene index, suspects index, offenders index, missing person index, and unknown deceased person index. The 5 kind of categories of information we should keep with the data bank. Now, in this bill, what happened that the persons who have been convicted or arrested for committing an offense which provides for punishment more than 7 years, they were under obligation to give the body sample, DNA sample for testing. Then the consent was not given much importance. But however, those who have been convicted or arrested for committing an offense less than 7 years imprisonment, their consent had to be obtained. That was the provision in the bill. But about the minors and the victim disabled persons, the consent of their guardian or relative or parents had to be taken under this bill. Now, therefore, this is what the depositing the DNA information. Now, then, DNA regulatory body was anticipated in this legislation, in this bill, which supposed to give a kind of advice to the government on DNA matters. And even the composition of this body, the DNA regulatory body, according to 2019 bill, the chairman should be the Secretary, Department of Biotechnology, then experts in the field of biological sciences, and Director General of National Investigation Agency, that is the NIA, and Director of CBI. CBI, NIA, Secretary, Department of Biotechnology, and experts. Now see the composition which was suggested in this bill. Government control. And the functions which were given to this regulatory body is to accredit the forensic laboratories, to advise the government on DNA matters, then ensure that all information which is being collected by the DNA data bank is kept confidential. This is what the scheme is. Now, what are the offences which have been listed in this bill? Now, Part A, Part B, Part C, Part D. Now, in Part A, they said that the persons who have been convicted or accused of committing an offence under Indian Penal Code. All the offences. Because I will have to refer this one when I come to the law in existence. Now, then Part B, special legislations, only few they are indicated, like Immoral Trafficking Act, MTPA, the Surrogacy, Domestic Violence, Foreign Civil Rights Act, SST Atrocity Act. These are indicated in Part B, persons convicted or arrested. Part C is civil matters like parental disputes, is relating to pedigree, is relating to assisted reproductive technology, that's surrogacy, all these things. Now, Part D, medical negligence, then abandoned and disputed persons. Now, the bill had a specific legislative paradigm. Now, then they talked about DNA laboratories which have been accredited by the DNA regulatory body. They need to carry the samples and they need to be deposited with the DNA bank. And to what period the bill was silent about, maybe perpetual one. Now, one of the provisions of this bill was that whosoever used this data in an unauthorized way, punishments were provided. Now, punishment ran up to 3 years imprisonment or fine up to 2 to 3 lakh rupees. Now, this was the structure of the bill which government withdrew on 24th February 2023 for certain reasons, which I will come a little later. Now, therefore, what is wrong with this bill? Why government had to withdraw this one? What is wrong? Probably there was opposition that this bill talks about two important things. Storing DNA data forever of the persons who have been convicted or accused of being under trials, committing an offence indicated in Part A, Part B, Part C. And therefore, they thought that this is going to go against the tenets of Article 21 of the Constitution, which talks about right to privacy, because the state data can be used, can be misused. And the third drawback of this bill was that it was government controlled. Government control, and therefore data can be manufactured, can be used, can be manipulated for certain reasons other than the reasons for giving evidence or adducing evidence to this. Therefore, the third thing which was very peculiar in this bill was that whatever was asked to be done by any of the agencies under the 19 bill, the courts were kept out. No person had any access to a court to challenge the actions of either data bank or regulatory body or anyone. That's done in good faith. Therefore, no courts were kept outside the jurisdiction of this DNA one. That means if you have any grievances against any one of these institutions, you need to suffer in silence. That was one of the drawbacks of this. And therefore, a lot of power was given to the government because recommendations, directions of the government will be binding on the board and regulatory body. And this is what the drawbacks were. Now, coming to the question, why did government withdraw this bill? Now, it made 2 attempts. 2019, passed by Lok Sabha, not passed by Rajya Sabha. It lapsed, again reintroduced, passed, referred to Select committee recommended certain changes. Then law commission recommended certain changes. But instead of putting a revised bill on the floor of the House, government would do it. What could be the reason? What could be the reason? Now, reason to me as a student of criminal law is that already one legislation was in place, having the core of this law in that legislation. I am referring to the Criminal Procedure Identification Act of 2022, which repeats the Prisoners Identification Act 1920. It repeats. Now, this act is now in place. This act is now in place because this act came into force on 4th August 2022. Please remember the dates. 4th August 2022, this act came into force. The Criminal Procedure Identification Act 2020, August 2022. Government will do this bill on 24 July 2023 when there was an opposition. Opposition on the grounds of constitutional rights, human rights, and ethical objections. Now, what's about this Act of 2022? Now, whatever was indicated in the 2019 bill, they were put in this act. But I don't know how both the houses passed this act. Now, under this act, any person who has been convicted, now please listen very carefully. Now, this act really goes a step ahead than the 2019 bill. A step ahead, but still that act is there. Now, under this act, any person who is convicted of an offense, punishable under any law for the time being enforced, any law. Now, while 2019 bill has specific indications, IPC and special laws. Now, this act says that person convicted of any offense under any law for the time being enforced, any law. Now, it enhances the scope of so-called DNA technology. Then any person who is arrested in connection with committing any offense under any law for the time being enforced. Then third category of individuals is any person detained under any preventive detention law. Any preventive detention law. That means these persons were under obligation to give measurements, including biological samples. Please take a note of this. Now, a person who has been convicted of, arrested for committing any offense under any law for the time in force, a step ahead than the 2019 bill. At least they have indicated the stations. But here, any law for the time in force. And persons who are detained under detention laws, they were under obligation to give bodily sample. Now, this, I will not go into much more detail because I want to just indicate the reflections is that now any person who resists giving body sample, then that will be an offense under section 186 of the IPC, that is obstruction of the public servants. Now, measurements had to be given of these three persons. What is the measurement definition? Measurement includes finger impressions, palm print, photographs, retina scan, physical and biological samples, and their analysis. Now, therefore, all these persons convicted, arrested, detained, are kept under obligation to give bodily sample for testing. And who has to give this one? Who has to give this one? The police officer or a warden of prison. If he is convicted, warden of prison is authorized to take the samples. And in case of arrested person, the police officer is supposed to take samples. Now in that case, therefore the point which I am trying to draw your attention to is that this act goes much more beyond than the bill which will come. Therefore, the government will do it. because already the legislation is in place, and the second house of the parliament was resistant to, because obviously there was no majority for the government to make it a law. Now, NCRB, National Crime Records Bureau, is authorized to collect the record of all the samples. NCRB. Now, please take note of the fact. NCRB is not a statutory body. It is a body created by Government Resolution 1986. It is a resolution body, not a statutory body. And the NCRB is given power under this Act of 2022 to collect the record of measurements from all the states, union territories, or any other law enforcement agency. This is one. Store, preserve, destroy the record of measurement at national level. Store and process the records with relevant crime and criminal records, and share and disseminate such records with any law enforcement. And therefore, the power is given to NCRB, which is parallel to the data bank, which was planned in the 2019 bill. NCRB, again I say, this is a body which is not a statutory one. It's created by Government Resolution 1986. NCRB, National Crime Records Bureau. Now look at the structure which you find in this act. Now, there are some kind of indications who are not under obligation to give the body measurements. Law is very clear. Now, who are they whose body measurements cannot be taken? Now, particularly, the persons who have been arrested in connection with an offence under Chapter 9A of IPC. Chapter 9A gives the offences related to elections. Or Chapter 10 of IPC deals with contempt of lawful authorities or public servants. Now, samples of such persons cannot be taken without written approval from a police officer. Now, look at the chapters: election, offence related to election. Now, see the kind of hidden agenda which you can easily see. Chapter 10 and Chapter 9A. Their samples cannot be taken without prior written approval of the police officer. Now, no measurements can be taken of the persons who have been detained for violation of prohibitory orders under Section 144, 145, 151 of CRPC, prohibitory orders, unless he is charged with any other specific offence. Because law allows detainees under prohibitory orders, but now this adds a kind of qualification. Unless they are charged with some other offence, their measurements, their body sample cannot be taken. Similarly, the third category of exception which you find here is that persons who have been accused of are detained under Section 107, 108, 109, 110 of CRPC, that is security for good behavior. Their samples cannot be taken unless it has been ordered by the order to give security for their good behavior. Now, this is what the kind of exceptions or the qualification have been added, but the basic premise remains the same. The person who have been convicted of, arrested for committing any offence under any law for the time being force, or person detained under prohibitory orders. Their samples can be taken and data can be stored by NCRB for 75 years. 75 years. Now, again, there's a detailed provisions. I don't want to go into that one. How to collect the record, how to disseminate this information, for what reasons it can be used. But there's one provision which you need to take into account is that if someone has unauthorized use of this data with NCRB, now what law says that they will be punished as provisions of IPC and IT Act. Now, no indications, no mention of any provisions. According to IPC and IT Act of 2000. Now, this is a way. As a student of criminal law, I generally say that criminal law has to be very, very specific. Criminal law cannot be vague. Criminal law cannot be vague. And this is what has been done by the Act of 2022. Now, therefore, compare these two, the law which was aborted, there's a bill of 2019, and the law which is in existence, you will find interesting comparisons. Now, what government would not do directly, it did indirectly by the Act of 2022 about the DNA technology, body sample analysis, showing the data for 75 years. Punishment is very vague. No. Therefore, we need to have this kind of observations when we talk about this DNA technology, vis-a-vis use of the technology as evidence for identifying the persons, detecting the commission of crime, convicting them. But the basic principle of criminal law is that no wrong person should be convicted. Innocent person should not be convicted. Now, there's a possibility of convicting innocent person by using this information. Now, therefore, why am I having this apprehension as student of criminal law? Because DNA is collected with small quantity of, maybe analysis of extremely small quantity in nanograms or picograms. Then probably the sample collected from the crime scene may be contaminated because number of persons may be there, maybe committing or maybe bystanders or maybe onlookers. The samples may be there on the crime scene. If investigating officer can connect that one, there is a possibility that wrong inferences may be drawn in a laboratory, and those persons may be subjected to a sort of humiliation or maybe sort of torture. Therefore, what is that which we need to do? I have some theoretical questions and some pragmatic questions which you can discuss maybe not in the seminar, maybe outside the seminar. That is it constitutionally permissible to use a body sample against the will of the accused? This is the question which you need to address to a student of law. Now, does it not violate your fundamental right to privacy, which Article 21 loudly guarantees us? Then, what the evidentiary value of DNA profiling or maybe samples? Now, is it a probative value or is it conclusive one? Well, if it is a conclusive one, then there is a possibility of injustice. If it's a probative one, again there is a possibility of circumstantial evidence or supporting evidence. Now, the third question is that are detection methods scientifically valid and reliable one? Detection methods collected by IO, investigation officer, are scientifically valid and reliable one. Now, does the sole reliance on the DNA profile alone meet the requirement of proof beyond reasonable doubt? Because in the prosecution, who is supposed to prove its case beyond reasonable doubt. Now, can this kind of technological evidence really meets the requirement of that requirement in law? These are the theoretical questions which you need to look into in the light of proposed law and in the light of existing law. Now, the pragmatic questions are, now, are samples taken from crime scene immune from contamination? Possibility cannot be ruled out. The samples which have been taken from crime scene may be contaminated because they are obtained from various sources. The second pragmatic question is that are there any SOPs, standard operative procedures? So far, no. Even if you look at the rules under 2022 Act, there is no kind of standard protocol or procedure being given. Now, the third pragmatic question is that is match in inverted commas with the samples taken from crime scene and from the suspect sufficiently upright in all cases? Upright matching is upright one. The fourth pragmatic question is that are the testing laboratories fully equipped with the mechanism that detects such contamination? Answer is no. Are they really equipped with detecting these contaminations of the samples which have been taken from the individuals and the inferences drawn from that? And last but not least important question is, are criminal agencies, the CJDs, are criminal agencies adequately trained to assess, appreciate relevancy of the technological evidence? Are they really trained, including investigating officer, prosecutor, adjudicator? Are they really trained to appreciate the evidence which has been gathered from technology? Because all these cases are tried at the most district level. Are they really trained? Are they really trained to appreciate this kind of evidence? These are the pragmatic questions we need to. Now, what's the way forward? Taking clue from Dean Ma'am. What's the way forward? Now, I have listed some kind of way forward to create a balance between these kind of contradictions and competing claims. The first thing is that we should give priority to balancing crime detection and privacy. We need to have a mechanism in place which will create sort of balance between crime detection and right to privacy. The second one is that we must establish independent regulator. Now, regulator is government dominated, which is a possibility of this data may be misused for certain reasons. The third is that excessive powers given to NCRB under the existing law are likely to be abused in the absence of adequate safeguards. Likely to be abused, NCRB. The fourth one is that some effective and functional remedy with unauthorized collection, retention, and use of DNA samples should be provided. As of today, there are no safeguards in the law. There are no safeguards. Only vague punishment, punished under IPC and IT Act. Nobody knows what kind of punishment which provisions will be made applicable. And this is a very flaw in criminal science, But that is that. These are some of the prosecution needs to convince the judge that the method used by the IO is reliable one, authentic one. Now, how is the prosecutor is going to convince the judge, whereupon technological evidence, that the method which was employed by the laboratory or the police officer or by the prisoner was more authentic or reliable or accurate one, because nothing is in place for the legal framework. So therefore, if you look at all these things, what I conclude by saying that DNA profiling is not on trial. But what is on trial is the accuracy of it, accuracy of the information. Now, therefore, we need to create a sort of balance between right and the need. Right to privacy, ethical rights, and need is to have the kind of evidence which would convict the culprit who has really committed an offense. And this is what we need to do judiciously. And therefore, just I have tried to do my reflections on this. I have not drawn any conclusions. I tried to do my reflections as a student of criminal law about the legislative paradigms which are emerging and which are in place about use of forensic science in criminal justice system. And please keep in mind that any law which contravenes fundamental rights, the Article 13 clause 2 is illegal, is ultra-virus. And I'm sure if someone challenges 2022 Act, there's going to be an ultra-virus because it really denies, condemns, abridges, violates fundamental right, because a criminal law has to be specific. This law is very unspecific. There are my reflections on the existing and emerging legislative paradigms about use of forensic science in criminal justice. As I said in the beginning, word justice is an elusive one. We need to take care of all the players in the justice, that is the victim, the perpetrator, and the community as such, and need to create a kind of working balance without hampering anybody's right. Thank you.